right, welcome back to the Judicial Proceedings Committee. Today is Wednesday, April 2nd, 2025. We're on voting list number 22. We're going to start off with concur, not concurs, and we're going to start off with John.
Senate Bill 619 as amended by the House is identical to House Bill 788. It's cross-filed, which this committee just passed unanimously last week. Is identical. The House didn't change it. Well, they changed it to be identical to what we passed. The JPR just passed. Identical. Senate Bill 540 as
which is Prince George's County illegal dumping and litter control, video evidence and reward programs. The House made a couple of changes to the disposition of fines in the bill. Provides that in general, fines collected shall be used to pay for litter receptacles and posting signs as required under existing law and for other purposes related to the removal of or control of litter. That's existing law. For the pilot program, the new language would say that fines collected in Prince George's County shall be used to pay for maintenance costs, litter receptacle and signs, the removal or control of litter. It also authorizes the local governing body to refer unpaid or outstanding fines to the central collection unit.
Prince George's County delegation bill, right?
This is the delegation bill.
All right, so this is Prince George's County delegation bill. Defer to the Prince George's senators.
I submitted to the, because we weren't able to get the amendments quite drawn out on the Senate floor. So I submitted these amendments on the House side, and I concur, being that they're my amendments.
All right, the motion's to concur. Is everyone okay concurring?
Maybe.
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 Maybe. All right, motion's concurred. It's been seconded. Is everyone okay being recorded in the affirmative for the concurrence? All right. Jamie, do you have anything else?
I do, but I just need a second.
This is Senate Bill 338. As passed by the Senate, the bill authorizes the operation of speed cameras on I-695 and 83 in Baltimore County. The House amendments did several things. First, they strike a restriction on the amount of revenues that the State Highway Administration may use to recover its costs in operating the cameras. The House amendments alter the number of cameras that are authorized by the bill. Specifically, under the House bill, there are 4 cameras in each direction on 695 authorized and 3 in each direction on 83. The House amendments provide that no camera may be operated within 5 miles of another camera being operated in the same direction. They require SHA to place a device displaying a driver's real-time speed near any speed camera being operated. They reduce the time period in which SHA would be required to issue warnings in lieu of citations from 90 to 30 days. And they also alter the reporting requirement in the bill.
These are a lot of changes, and it sounds like they struck out all the changes that were made on the floor of the Senate. I think we should go to a conference committee and iron out these differences.
So motion's not to concur?
And who do you want to serve on the
Make a motion to not concur and remand it back to committee for further.
All right, so
Senator
No. Sidner and West are both Baltimore County people. Jeff? Yes, my bill. And put Jeff on?
This on speed cameras.
We don't have a vote in the city, remember?
Sid, Nor, and Jeff. All right. Josh.
Jamie, are you ready?
So we have Senate Bill 202 for concur, not concur. Senate Bill 202 is the statewide DNA database system. It's the Department of State Police's departmental bill. The House amended the Senate bill to conform to what the Senate has already adopted with the House bill. So, yeah, motion to concur.
Motion's concur. Second. Is everyone okay being recorded in the affirmative on the concurrence? All right, excellent. Who's got next? Josh? You have anything?
John, you ready?
Josh, do you have anything else? No. All right,
This is for concur, not concur, Senate Bill 513. This is about the notice regarding what local governments have to do when it intends to record modification to an unlawfully restrictive covenant. As passed by the Senate, they either have to publish once per week and for 4 consecutive weeks in newspapers or post it on the official website of the county or municipality. The House simply amended it instead of saying or to say and, so the House version requires them to do both of those notice options.
Concur. Yeah. Thank you.
concur. With that, is everyone okay with the concurrence? All right. Is everyone okay being recorded in the affirmative on the concurrence? All right. Boom.
Again. Senate Bill 540, again for concur, not concur, is identical to the cross-file that passed the Senate.
All right, motions to concur. Seconded. Is everyone okay with being recorded in the affirmative on the concurrence? Okay. Next.
Okay. Senate Bill 46, as passed by the Senate, made numerous changes to the wrongful detainer suit process. Among those was sheriff immediately executing warrants, expediting the process for various stages of the wrongful detainer process. They made it identical to House Bill 164, which is still in the possession of the committee. And under that, it simply just says the hearing has to be held within 14 calendar days. And it also makes a change to the notice requirement. So the notice now, if they cannot find the person after 2 good faith attempts at trying to serve process on the person, they can file an affidavit with the court describing these good faith efforts, mail a copy to the last known address of that person, and affix it to the property. And the service, all the service has to happen within 4 business days after the complaint. I also noticed that. I also just want to note that the sponsor of Senate Bill 46 has agreed to have this change made to his bill.
Real? Okay. All right. Senator Folden.
So thank you, Mr. Chairman, isn't this the bill, like, the House bill you referenced that it conforms with is not the cross-file to this bill?
That's correct.
That's my first concern and question. My second is this the bill about where we moved it to like 4 days or something? And now we had a very robust discussion about that time frame, and now we're talking about 14 days again?
That's correct. This would be
I would say we shouldn't fight that. We should not
Pardon?
concur. We should go to conference on this.
Yeah, I just wanted to make sure that this was the thing, because it doesn't even, the referenced amended bill to conform with isn't even the cross-file, so, thank you.
The question that I had, did you say that with the notice provision, they're supposed to mail it to the last known address? of the person?
So they have to mail a copy of the, to the last known address of the person in actual possession, and if different, to the address of the residential property subject to the complaint.
But if someone is squatting, would the last known address be the address that they're squatting at?
It could be.
Maybe. Thank you.
Not concur, motion's not concur, it's been seconded.
Who do you want on the conference committee?
All right, let's put,
Who do you want to chair?
Okay. Also for concur, not concur, Senate Bill 160 as amended by the House is identical to its cross file which passed the Senate.
motion is to concur. Seconded, is everyone okay with being recorded in the affirmative on the concurrence? Okay. Do we have any more concur enough?
Yeah, I got one more. This is Senate Bill 150, which is also identical to its cross file which passed the Senate.
Second, is everyone okay? All right.
House Bill 707 is nearly identical to Senate Bill 618, which has passed the Senate unanimously. It requires an initial and renewal application for a license, ID card, or moped operator's permit to allow an applicant to choose to indicate on the document that they have a non-apparent disability. There are two very minor differences between the bills. Both of them are on page 5 of the bill. The first is a technical issue on line 5. There's a reference there to a subsection E3 that should say subsection E3 of this section. And the other change is on line 15. It requires MPTSC to immediately implement a training concerning the interactions. The Senate bill does not have that word immediately in it.
So I want to conform to what the Senate passed. So this is Eric's ID law. It passed out of the House. It's on the governor's desk already. So just I'd make the bills identical since the House already passed it. So the motion would be to conform it to the Senate bill. Second, is everyone okay with that? All right, excellent. All right, so we're going to move on to House Bill 860. It's John.
House Bill 860 prohibits a common carrier or an employee of a common carrier from causing damage to public infrastructure that necessitates the closure of the infrastructure. A violation of this is a prohibition is a public nuisance, and the state or council designated to or retained by local government can bring an action against the common carrier for the public nuisance caused by the violation. They can seek injunctive relief, declaratory relief, and compensatory damages. A common carrier that commits a violation can be liable to the state or local government for civil penalties of $1,000 per day for each day of the public nuisance. There is an amendment in your packet that removes transportation network companies such as Uber or Lyft from the definition of common carrier under the bill.
So I'd like to move the amendment. All right, excellent. Now the bill's before you is amended. Motions for, move it. Seconded. All right, Senator McKay, go ahead.
Full disclosure, this has to do with some bridges that were hit in Cumberland. And two of them, the common carrier is working with getting funding and working with the city and the state, or city and the county. The other one, which I actually am 1 block away from. And so I'm going to abstain from the vote, just from an ethical standpoint that, like I said, it affects me directly. So, but it is a good bill, and I believe it addresses the issue that the good delegate brought up.
Very admirable of you, Senator, and ethical. So there you go. All right. Are you ready to? It's okay.
Yep.
You got it? All right. So now we're going to move on to House Bill 1123.
House Bill 1123 is similar to Senate Bill 181. The bills make various changes relating to medical and geriatric parole. You should have in your packet a copy of a reprint of Senate Bill 181. It should have written on the top HB 1123. This is the version of Senate Bill 181 that's currently on third reader in the House. Just to kind of go through the differences between that and what the Senate passed on Senate Bill 181. In terms of the changes to medical parole, the bills are identical. The difference between 181 as it currently stands and what the Senate passed is related to geriatric parole. So the approach that the House bill took was to require the Parole Commission to conduct risk assessments for certain individuals who are 65 years old and have served 20 years and meet certain other eligibility requirements, and to authorize risk assessments for other individuals who meet those criteria. And then the House took the additional step of authorizing the use of Justice Reinvestment Act savings for the Parole Commission to hire individuals to do those risk assessments. And then once those risk assessments are done, the names of those individuals have to be sent to the Parole Commission to have parole hearings done for them. So that's kind of the specific approach that the House took, which was different from what the Senate did. I think the motion may be to conform the House bill to the current version of the Senate bill over in the House.
So this was a bill that there was a work group that worked on, which you'll remember because you were sitting there taking notes. And at the end of it, it was like a kumbaya moment where the state's attorneys, the public defender, everybody signed on. In your view, did the House do anything to this bill which could cause anybody present in that work group to lose faith in the work product that they arrived at the end of the work group?
Well, so yeah, the both sides seem to be okay with this, right? So again, for the state's attorney side, this adds in those risk assessment tools. So that's actually more beneficial from their perspective.
Or maybe from the public defender's perspective, depending on the circumstances.
I think just given the circumstances of what else they're getting in the bill and the other concessions made for the age, bringing it down to I think 65 now. I think everyone is still on board with this.
Okay. Good.
I don't know if you care to comment, Dorothy. You were a party to some of these discussions across the street. I've spoken to the sponsor of the bill. She is okay with the amendments.
Okay, great. So then if she's okay, I'm okay.
Okay. Okay.
It must be okay with this.
The governor asked me to convene a parole work group, which we did. We met a few times and came up with the provisions on the geriatric parole, which included the risk assessment and included using JRA funding to pay for more risk assessors. And we ended up kind of melding that into the two bills. The bill that was SB 181. I think we had a lot of back and forth, but I think at this point we can say everybody's in agreement.
Yeah. I mean, the substance of the bill that we did doesn't change, just absent the risk assessments and when they're applied. So like the 65, 20 years, all the same. The factors to be considered, all the same.
One of the big problems is that the people who are, the incarcerated individuals are sitting there because there's only one guy who does the risk assessments. So we would add I'm proposing 5 more risk assessors to clear out the backlog and get the whole process moving. So I think all around, everybody feels like it's a win-win-win.
Senator West.
Could I just say, this is what JPR, in my view, does best. Get all the stakeholders in the room and work together to come up with a consensus product, which is the best product. So I couldn't be more pleased to vote in favor of this amendment, or this bill.
So then the motion, excellent. Thank you for that. And the motion is to concur, right? To conform to the House, yeah.
What is currently?
In the Senate bill. All right, so the motion's conform. We made the same changes, but the Senate bill, which is over in the House, I think is on third reader now.
It's on third reader.
We are now conforming this
The
House
House
bill to what
bill,
the Senate bill is
yeah.
now.
Which means we're taking the House with us.
Yes, which were done in concert with the senators too, but yes. Yeah, yes. So the motion's favorable with the amendments. Is there a second? Second. Is everyone okay being recorded in the affirmative? Yes. All right. Okay. Excellent, okay, got it, yep. Senator James is in. Got it.
Is Bolden voting?
So House Bill, Senator Folden. How do you, we're on House Bill 11. This is the medical and geriatric parole. Are you up or down, the amendment?
No, I'm out.
Oh, he's down, all right, so he's down. All right, so House Bill 1123 with the amendments passes.
Sorry, Mr. Chair. Can't get her to come up to the podium anymore, so I figured I needed to go out to the gallery and speak to the OAG.
All right, we'll now move on to House Bill 1125.
House Bill 1125 expands the requirements for the workgroup on home detention monitoring to include studying and making recommendations regarding the policies and practices that apply when a person violates a condition of monitoring, such as absconding, and the responses from the Department of Public Safety and Correctional Services and home detention monitoring agencies when a person violates a condition.
Motions for favorable. Second. All right, it's been seconded. Is everyone okay being recorded in the affirmative in House Bill 1125? All right, House Bill 1125 passes unanimously. Okay, so this is House, we're gonna. So we're going to go to Josh with House Bill 1464.
House Bill 1464 establishes an alternative registration process for rental fleet vehicles and requires the MVA to issue distinctive plates for rental vehicles registered under that process. Under the bill, the owner of a fleet of 5 or more rental vehicles may register the vehicle in the fleet under the bill's provisions or under current statutory provisions that apply to the registration of rental vehicles. The annual fee for registration of a rental vehicle is the same fee that would apply to rental vehicles under current law.
All right, it's been a motion for favorable, it's been seconded. Is there, is everyone okay being recorded in the affirmative? Yes. House Bill 1464 passes unanimously. All right, now we'll go on to, you ready? John, you ready? Yeah. Yes.
House Bill 785 prohibits the governing documents of cooperative housing corporation, condominium, or homeowners associations from prohibiting or restricting the establishment and operation of family child care homes or large family child care homes, or using the roads, sidewalks, and other common elements of the common ownership communities by users of such child care homes. It also prohibits these communities and local jurisdictions from limiting the number of children for which these child care home provides family child care to below the number authorized by the Maryland State Department of Education. This bill does not apply to housing that is restricted for occupancy to individuals over a specified age.
All right, what's your pleasure? The Vice Chair has moved favorably. I will second. Further discussion? All right, is everyone okay? Go ahead. Yeah.
I'm opposed.
All right, let's do a roll call on it then. Actually, is everyone okay with that? Okay.
Here, did we have a Senate bill on this? Or is this only a House bill? It was just a House bill. So could someone explain it a little more? What I'm concerned about is that you have people like living in close to each other in a multifamily building of some kind or another, a condo or a co-op or and all of a sudden you've got all these children running around making noise, and would this prevent like a senior citizen condo from preventing childcare facilities in the condo which was established for the purpose of senior housing? That's my question.
No, it exempts any community where age is a part of that. So if there's a housing community that is restricted to occupancy for individuals over a certain age, this does not apply to that.
Okay, that helps. Thank you.
Oh, I just don't, because I don't think we had a hearing that I can recall. What is the problem that this bill seeks to solve? Is there an actual problem? And where is it? Certainly not in Hartford County.
Senator Walter.
So the answer is just the dearth of childcare facilities, and I think
Sorry, say that again.
The answer is there are not enough childcare facilities, and especially home-based facilities, and that there is a current regulatory barrier to increasing the number of slots, and then increasing the number of slots lowers the prices for everyone. We know that childcare is excessively expensive, so providing more capacity allows for lower prices. I would add that if you have concerns about this bill, the bill does not stop our locals from providing zoning ordinances that would restrict the use of these, about where these facilities go, including in multifamily, although I don't think that is the basis of the bill. And it certainly doesn't stop the state from regulating. It's just saying that homeowners associations, which as we know are run by volunteers, not necessarily professional
I can't
experts.
hear about a fraction of what you're saying.
I apologize. I'm far from the mic, and especially these mics up front are difficult. I was just re-emphasizing the point that was made during the hearing, that this does not prevent our locals from utilizing their inherent zoning and land use authority from regulating these facilities, nor does it prevent the state, the Department of Education, from continuing to regulate these facilities, both as to size and as to ratio. Okay. It simply limits the ability of homeowners associations, which are non-governmental agencies, from doing that regulatory work that should be done by elected representatives.
Are you aware of, are there homeowners, this isn't, to my knowledge, happening in Hartford County, but are there homeowners associations that are, I don't know,
that are
being
making
difficult?
these, yes. So that was the testimony during the hearing. I haven't heard that in Montgomery County.
Okay.
Don't forget, the sponsor of this is from Howard County.
Howard County.
Which utilizes more extensive kind of homeowner association form of government than
I
other
see.
jurisdictions. And that may be impacting the ability of that county to expand the number of childcare slots.
And this could not be done locally with their own local ordinances? Is this non-mandatory in any event? This is like authorizing but not mandatory? I'm sorry.
That's a question for
I could pull that up. I could
counsel.
grab the bill real quick. I'm
I
sorry.
don't think it's enabling for the locals. I think because we, as you know, from Delegate Holmes coming over, we actually, state has a surprising amount of authority over HOAs that really should be with the locals. I agree with you. But ultimately, I think the authority is with us. I think that's why that. Oh, that sounds
What do you
great.
Yeah.
What'd you say there? Yeah.
There's a bill on the list that I think will address.
So it doesn't mandate this in like Harford County or anything, right? That's not, or any county that doesn't want to do whatever this bill does. I'm sorry. Is that right?
Well, no, well,
I
it
want to
is-
be careful not to mandate things to a county that didn't ask to be mandated to.
Sure. This is generally prohibiting the governing documents of these communities to do that. It would also prohibit local jurisdictions from limiting the number of children for which can be in these homes to below the number that's authorized by the State Department of Education already. That's the only thing that's prohibiting a local.
So does the bill say you just can't, is it that you don't have governing documents that directly limit this? Or are we saying that the inherent authority of HOAs to do, just to manage themselves, we want to make clear that they don't delve into this area? Is that how it's written?
It's saying that these governing documents cannot prohibit these family child care homes
Can't do
in their communities.
Okay, all right, thank you. All righty.
So if anybody can remember from the hearing, I'm reading Mako's, they support with amendments, but it mentions that the recent 2023 report of the Commission to Advance Strengthening Firefighters and EMS in Maryland highlighted childcare as one of the 3 top barriers to recruitment. Anybody remember what they said about that, or? No? Okay, thank you.
Thank you, Mr. Chair. So when I was looking through this, I see that here again, this body, I kind of want to echo, the sentiment of my good friend here from Harford County, and what are we trying to solve? And I'm not sure that I fully understood the answer that was given. So when I look at the Community Associations Institute from Maryland, it says that this bill would infringe upon the ability of these communities to self-govern and to adapt or adopt reasonable rules and regulations that such communities through their internal democratic processes regarding the safety and security of their communities and children and families who may be served by family child care homes in those communities. While the CAI certainly understands the need to have sufficient child care services available in Maryland is an important and laudable goal, members of specific common interest communities are best positioned to know the capabilities of their communities to support such services and should be permitted to make these decisions. They go on to say that some members of the communities have already decided to purchase homes in these communities because of already existing use restrictions and recorded documents that this bill would abrogate. So I'm not sure what we're trying to solve here, but I certainly see the problem that we're creating. We're putting a regulation in place for something that I don't even know that I've never even heard of this problem.
Well, look, I mean, I think, so all the way from the comptroller's analysis on our economy and people and their inability to re-enter the workforce, childcare was cited as one of the major impediments for people going back to work and participating meaningfully in the economy. The Chamber of Commerce, I thought, provided some very compelling testimony that I think answers the question that the vice chair lifted up, to borrow a phrase, about the dearth or lack of childcare facilities and access to childcare and the price of childcare. So the passage that I thought was the most compelling was that The Chamber believes that HB 785 is a necessary step to increase access to child care facilities that promote the well-being and effectiveness of Maryland's workforce and their employers. Over half of Maryland counties are deemed child care deserts. In 2023, Ready Nation projected a $2.2 billion, with a B, annual impact in Maryland solely from infant and toddler care shortages. This staggering figure doesn't account for the impact of the lack of affordable access to accessible care for older children on our workforce and on our tax base. So the answer is that we're trying to provide for more affordable child care facilities and more affordable access to folks that can get back in and participate meaningfully in the economy.
And I appreciate that, but childcare is so expensive, especially for those under 2 years old. And all the other fees and everything else we're piling on in the past 2 years, I'm not sure that this is going to help at all, because we're not doing anything to help people go back to work. We're just doing more to run them out of the state. And this is another example where we're trying to regulate something that we have no business in, and I just find it, so, I also find it very ironic that the Maryland State Board of Education misspelled education, but that's another discussion, so.
Well, that's not good.
No, it's not.
All right.
But it's in there that way, just so you can all go look in your testimony.
I do appreciate my education, but all right. Senator Love.
Thank you, Mr. Chair. And I want to thank you because you took one of the things I was going to say, which is about the Chamber writing in strong support of this and talking about how important it is for our businesses. But also, I was present for the House hearing last year on this bill, and there were a lot more examples since it was sponsor only over here. So it really is about opening up access to more childcare and more affordable childcare. And I don't remember if I was the one who seconded it, and if I did, that was why. Thank you.
Thank you so much. I am all for child care and affordable child care, having gone through that myself. What I'm just trying to understand, I don't like, I think HOAs, people buy into them for a reason. So outside of Howard County, do we have data that says that HOAs outside of Howard County are the obstacle to affordable child care and the reason we have child care deserts, or in any way contributing other than what happened in Howard? Did anybody look at this before we jump in and just make a broad, statewide law on the matter? Because I support the child care, but I support the autonomy of HOAs, and I just don't know if we have enough data. If we do, then I'm with you. So just let me know what we know. Does anybody know?
So I'll go now on to MACO's.
I don't have MACO's.
It's in the bill file.
No,
they
my
cite a
staff just didn't
report,
print
which
it, damn it.
it's the recent 2023 report from the Commission to Advance and Strengthen.
Oh, good. What does that say? I don't have MACO.
We did not. But they cite several reports that talk about how
good.
child care is one of the major impediments.
So there's a MACO report from 2023.
I think we have a misunderstanding. We're prohibiting an HOA or other plans from restricting or prohibiting the amount of kids that are allowed. So if I understand Senator Folden, we actually are allowing more kids to be in the condo or whatever that unit, and that kind of stuff. We're not telling them you're limited. We're not telling them you can only have so many. We're prohibiting that organization from restricting or prohibiting the amount of kids in there. So it's the opposite of what you're saying. So, no? Okay.
No, I'm talking about.
So right now, if you were a HOA, you could pass saying no kids allowed whatsoever. No, okay.
And people want to move into these communities because they don't want to if they're living in an HOA with a bunch of condos and they live there because it's quiet and peaceful, and now they don't want to have an area where somebody moves in and decides they're going to watch 15 kids during the day, and it changes the whole dynamic of the community that they moved into for that purpose. Again, government's getting involved in regulation. They created this HOA beast. You made the law, let them run it. It's the reason I don't live in an HOA anymore.
It's a law, I'm sorry.
Right, okay.
But it was just to restrict the HOAs from going
From
below
prohibiting
what's allowed
or
by the state
restricting?
level, right?
The State
Right?
Department,
So not to go below that number is what we're not going to do.
that's what it's prohibiting them,
Yeah.
either the community or the local jurisdiction from limiting the number of children to go below what is set by the Maryland State Department of
Who are
Education.
probably the most knowledgeable on what works. Okay, that makes sense to me. And I'm sorry, Mr. Chairman, what did you say? The MACO report says what that would be helpful to? I didn't know we were gonna do this, so, anyway, they have a report that says that what for,
It just said there was one of the major lack of access to childcare facilities was a major impediment to workforce.
for workforce, yeah, child,
Say firemen?
yeah, childcare.
This dude's got the greatest schedule ever.
Oh, yeah, all right. There we go. It's all, I'll go with it.
24 days off a month.
I'm good.
And they get paid to sleep.
I'm sorry.
Oh,
Rough. And then over half of my parents are steam giant.
Oh, I casted it out.
Okay, the Maryland Chamber of Yeah, it's fine.
Yeah, I'm up for it.
Vice Chair Wildstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
I'm going to pass for the minute.
Senator Muse.
Yes.
Senator Folden.
I'm going to pass.
Senator James.
I really want to thank everybody for helping me understand the bill. I'm going to say yes for now, and, I'll try to be supportive of the child care situation. All right.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes, yes, yes.
Opposed to maybe.
Maybe.
Senator West.
I'll go with an unenthusiastic yes.
Senator Folden.
Can I go with maybe?
You can abstain.
But because my good friend from Prince George's County had such an enthusiastic yes, 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 I'll go with a strong maybe. Yes.
Chairman Smith.
Yes. We're now going to move on to House Bill 163.
House Bill 163 authorizes the MVA to issue an out-of-state motorhome and recreational trailer vehicle show permit that allows the permit holder to participate in vehicle shows in Worcester County. The permit may be issued to a dealer of motorhomes or recreational trailers, which is licensed in another state that reciprocally authorizes those Maryland dealers to display or exhibit motorhomes or trailers at vehicle shows in that state.
Yep.
Did we have a similar, I don't remember being here for this particular hearing, but did we have a similar bill where the RVs were trying to do something over on the Eastern Shore and local businesses were concerned about folk coming in? I mean, is that?
Yeah, you remember that, right? We had the Senate crosswalk, we had this bill a couple years. All right, so House Bill 163 passes 10-1.
767.
All right, we're now going to go on to House Bill, Josh, ready? Or no, this is John. House Bill 767.
House Bill 767 establishes additional requirements once a court has issued a warrant of restitution and a failure to pay rent, breach of lease, or tenant holding over action. There is an amendment in your packet that removes all the provisions relating to the reclamation period. So now this bill only deals with requiring a notice prior to the eviction date. In addition, in that notice, there has to be a statement stating that personal property may be deemed abandoned and disposed of upon eviction, and that jurisdictions vary about that, and it gives them free legal advice and where to find that. The amendment also adds a provision that allows, I should also say, this notice originally had to be 14 days prior to the eviction date. Now it only has to be 7 days, at least 7 days prior. And it adds a provision that allows a county to pass local legislation to extend this 7-day notice period in that county.
So let's adopt the amendments, and then we'll just work off the bill as amended. So can we move the amendments? All right, second, everyone's okay being recorded in the affirmative on the amendments? All right, Senator McKay is down on the amendment. All right. All right, you don't like 7 days. Yeah, so good, Senator McKay, speak on it, yeah.
The reason I don't like 7 is for smaller jurisdictions as myself. We do rent court on Wednesdays and Fridays. You're automatically given your 4 days because you can then get your, might not be the right word, due process. You can instead, yeah. So to me, 4 days is the number where it needs to land. 4, because giving that person the rights that they have, in smaller jurisdictions, I can get the sheriff to come in 4 days. It's the striking of the balance.
I mean, look, this is, we worked with advocates on both sides of this and landed on 7. But I mean, I think it's actually important, John, can you walk through the timeline for just a failure to pay rent? I mean, of the three types of eviction, let's go through failure to pay rent because that's the lion's share of the cases. Senator McKay makes a good point because in his jurisdiction, you could get these, you get a court date, what, you said 4 days?
4 days.
The one thing that, I mean, look, we landed on 7. The one thing that makes me more malleable is that local jurisdictions can extend. If they have that debate at that level, and then they can extend the time for, 14 days, 7 days. So if Montgomery County wanted to go farther, for instance, they could do that under this. John, I think it's important for the rest of the committee, because I know we had a small work group, just to go through the timeline from failure to pay, and let's do failure to pay rent, let's do that type of eviction, and just the timeline from the 10-day notice, the court dates, the appeal, the actual notice for eviction, and so forth.
So for a failure to pay rent, first, the tenant has 10 days after receiving the notice to cure. And then after that, there is a hearing date set, which is, there's no, that's jurisdiction to jurisdiction based on capacity. And then after, once a verdict has been reached, they can appeal, they have to have this 4-day appeal period. They have to wait before acting on an eviction judgment. And then specifically for failure to pay rent, the court will order the tenant to leave the property within 7 days. If that does not occur, then the landlord comes back and requests that the court issue a warrant of restitution. And then under this bill as amended, there would have to be at least 7-day notice sent out before the date of the eviction, and then the eviction date occurs.
Got John, so 10-day notice, hearing date, 4-day appeal. The courts will hold on for 7 days. Then you said, then you have to give another 7 days?
No, so that, after that 7 days, then the landlord can request a warrant of restitution, and that is what the sheriff will execute to evict the person. Under the bill now, before that eviction can occur, there has to be at least a 7-day notice. So 7 days has to happen before that eviction date can happen.
So is the notice,
And that would be jurisdiction to jurisdiction, because there is testimony, like you said, some jurisdictions can, they can do the eviction quicker, some jurisdictions it takes longer. But there,
Right.
this bill
so
says there has to be
the
at least
court-
7
The court
days.
is going to automatically give 7 days. When can
You could give that notice.
notice?
You could give it at the same time,
On
for.
the hearing date?
As when you get the eviction, when the warrant of restitution is issued, then on that, when you could issue the notice for the reclamation at that point. That's what, I mean, that's what you could do.
Right, yes.
Okay, so I have the hearing date. It is found for the landlord to take his property because of failure to rent. And at that point, you can give the notice of the 7 days. Because if it doesn't, you're adding more to it. So if it's 7 days after those 7 days have gone, what has Judge Morsi said about this, with this compromise?
I don't think he's weighed in.
You probably ought to do that.
No, but
since he's in charge
you
of the-
could change the form. I mean, if they're gonna give a notice for the sheriff, then you could put that on the same form. But we have not consulted, in all candor, I've not.
And the reason I say that is because in Prince George's County, he had this issue, and in Allegheny County, he had this issue where those people that are using the ERAP services, that is, those funds that are help people from becoming homeless, those funds and the interpretation of that is that they can't even give those funds out, pledge those funds out until there is actually a conviction. Right. So that means what ends up happening is you got somebody who now has to get out, but now they're looking to try to figure out how to get the funds to stay, if the landlord wanted to stay. I know that that has nothing to do with this bill, but what I'm trying to get at is from the administrative judge in Prince George's County, not the administrative judge, but those who are administering those ERAP services, it was their understanding that you could not do it before that. So if we're giving another 7, it may be for another bill, another day. But they did have a problem with, because he told me on Monday night he did, because I was bringing it about Allegheny County. So.
That's a separate issue, and that money should be issued for prevention and not, after the fact, so, yeah.
I mean, I
100%,
get that,
yeah.
but I'd like to move it to 4, but it's whatever the will of the committee is.
Thank you, Mr. Chair. I know one of the things we talked about was not only making sure folks knew a date, but some level of time as well. And I didn't see that part in there, and I know we were kind of workshopping the amendment the other day, but time was left out. Even if it's not an actual time, having some level from 8 to 12, the eviction will take place.
Yeah, and like an AM or a PM.
Yeah. Just to give folks some level of notification. You say it's happening on?
So it's on page 7 of 12 on the reprint, but it's.
Right, it just says the date on which the warrant of restitution is scheduled to be executed by. It
Yep,
doesn't-
that's the notice, written notice of the tenant, that the restitution is scheduled, so that, you're gonna get 7 days' notice now. And this is, the genesis of this bill is the Todman decision, which is it's Baltimore City decision, it went up to the Fourth Circuit. It said that there had to be some amount of time for a reclamation, but there was no specified amount of time. So we've been arguing over 14, 7, 4, whatever, but.
Right. Is there a way for us to add an amendment just to get some level of time, just to make some specificity in there for folks?
Well, I think that's what this is. That's what this will give you 7 days for that notice that, hey, you've got to get your stuff.
Right, but let's say you give me the 7 days and I finally am able to get my U-Haul truck on that date, and then my stuff's outside the day that I actually got the U-Haul truck. At least so folks got some time period.
Just a date, time, morning or evening, or morning or afternoon.
And it doesn't have to be as specific. It can be between hours of this, X, Y, and Z.
So there are, can you speak to this with the sheriffs? I mean, the sheriffs, you want to come up? I'm saying, but he can give you the sheriff's. Senator Henson first.
Thank you. I think that we are, to Senator McKay's point, adding in an additional 7 days as we're discussing it. As I understand it, you go to court and then you can file for your warrant of restitution, and then the 7 days kicks in. So it's once you have your warrant in hand, and then if you're going to execute the warrant and evict the person, you have to notify them 7 days in advance of that. So it's not that you walk out of the courtroom, the court puts it on pause for 7 days, and then you file your warrant. It's you walk out, they have the 4-day appeal, you file your warrant, when you get it in hand and you know you're going to evict, then that's when the 7 days kicks in. So I just didn't want us to think that we were layering two different sets of 7 days.
That's what I was saying. It was nested within that initial 7 days of it. But you're saying that your sheriff can go and get. Yeah, other jurisdictions are quicker, but that's what I'm saying, that you're absolutely, Senator Henson's absolutely right.
24, Todd.
Is if we're trying to do, I keep on calling it due process, I apologize, but give somebody the right to appeal and all that kind of stuff. If they're in the statute, right to appeal is 4 days, then why are we making it 7 if by law it's 4?
Well, so the appeal happens after, so you get the disposition, and then the tenant has 4 days after that pocket of time to do the appeal. And then if it's upheld, then that warrant of restitution is issued. From that date, you've got 7 days for the sheriff. You got to give them 7 days notice for the sheriff to go say, hey, I'm, within this period of time.
So that's not 11 days?
What do you mean? I mean, it's,
If you got 4
that's the current.
days for your appeal.
Yeah.
And let's say you get denied your appeal, that means I have to give the 7-day notice on the 4th day?
Whenever the warrant of restitution is issued.
Okay. Normally, what my experience is that is the same day that the hearing is.
Yeah.
Okay.
7 days from that.
So you have 4 days to appeal. Why would that not be part of the 7-day notice? If you failed in your appeal, and I'm not using the word, I don't know what word to use as reward, but why does the landlord have to add that on the end of the 4 days?
They don't, in your scenario, it's included in. So if you're saying you have your court date, judge signs the warrant of restitution same day as court, but you just can't execute it until the appeal period is up, if you get your warrant signed that day and then you call your sheriff and they give you a date, you can still serve that notice on them and start the clock on the 7 days. The clock starts when you have your warrant. So most jurisdictions, they won't sign your warrant until after the 4 days is up. But if you're familiar with one where they will, you start the clock when you get the warrant. And you have your eviction date scheduled. You know you're going to execute the warrant.
I want to give just 1 second. I want to acknowledge Senator Augustine's here. No, this is great. We're in the midst of a voting session. You want to introduce your folks? I think it's great that they're coming in to watch our voting session.
So sorry.
No, this is great. Don't be.
Yeah, colleagues, forgive me.
No.
These are students from Howard University Law School. They came down to visit. Mr. Chair, you remember the heirs property legislation that we worked on, this committee worked on. There's some folks here who are interested in that space, but I also just wanted them to get an opportunity to see some of the work that you all do down here.
Excellent.
Is that okay?
Yeah, absolutely. Yeah, welcome. 1 L's, 2 L's, 3 L's? What? 2 L's, 3. All right, I just want, before, I know we're taking a little bit of an interlude, but when you all leave out of here, there's a portrait right between these two doors. It's a young Thurgood Marshall a picture that he took on the second floor of the Afro newspaper in Baltimore City. It's right after he won the Donald Gaines Murray case. Remember, the reason he went to Howard Law School, got that fantastic education, was because he was denied admission to his law school that was right down the street from where he grew up. He ends up going to Howard, linking up with some of the brightest legal minds of his or any generation, and then he becomes a civil rights attorney. Donald Gaines Murray applies in Maryland, gets denied. He takes the case, and they win. He gets admission. He desegregates the University of Maryland Law School, the rest of the university system, and that's the foundation for Brown. And so that's that moment captured out there. So as Howard University, future Howard University alum, but just check that out because it's a very proud moment for a distinguished alum of a fine law school. So anyway, yeah, there you go. The real HU. All right. Go ahead, Senator Charles.
Thank you, Mr. Chair. I'll remove my question about the amendment that I wanted to offer up for adding the time in. After speaking with the advocates from both sides, they're both fine with not adding the time in, so I'll remove that.
Thank you. I just wanted to say that Senator Henson is correct. If you look at the language of the bill, there's nothing that would require the landlord to wait. Once the warrant of restitution is issued, the landlord can immediately issue the 7-day notice. The only thing the landlord has to do is find out from the sheriff first what the date of execution is going to be. Once the landlord gets that, the 7-day notice can go out, even though the 4-day appeal period hasn't run yet.
Well, a couple of things. One is details and one is just a little more future looking. But I guess the question is for council. So I think some of us represent jurisdictions that have a tough time with this issue and don't bring the level of expertise that we do on this committee because we're specialized on landlord-tenant, whereas our county councils are more generalist. So I have a concern that if we allow certain county councils to go beyond the 7 days, some will abuse that authority in order to go on to a number that is so high that it is not designed to provide rights to the tenants, that it is designed to essentially not allow for an end to the leasehold at all. So I guess the question is, if we're allowing certain local deference to go beyond 7, is there a limiting factor? Like you can go between 7 and this if you want, but we're going to default to 7, or can that go in perpetuity?
But not more than 14 or something.
As the bill's written, there is no maximum that it provides for.
You could say, no. I mean, I understand. Since the bill, came in with 14, I'd be comfortable saying at least 7, but no more than 14. Or you go to 4, at least 4, but no more than 14. That's a good compromise, I think. Yeah, you're right.
Size, that's what I'm trying to get at.
Just a quick broader point. Part of the reason we keep coming back on this, and I know there's might be other legislation related to this at some point in the future, is that Maryland doesn't have a date certain for evictions. We defer to our sheriffs, which provides an incredible amount of uncertainty, both for the landlord, but most importantly, just anxiety for the tenant. Now, the tenant hasn't paid. If there's a warrant of restitution, you got a thing on your door, it shouldn't matter that uncertainty, because that should be your cue that it's time to move on. But I'm empathetic with that some tenants don't have that ability and need a little extra time to find their next space. When the advocates on this bill came to me to compare this time frame to other states, a reference was made to West Virginia, which has a longer reclamation period. But West Virginia, in part, has a longer reclamation period because they have a judicially determined date certain of the eviction date. And so we can't solve that here. We can't do that through an amendment. That's a big change in our law. But part of what we have done in creating a lot of tension within the committee between the tenant advocates and the housing providers is that we're trying to solve for an issue that we can't solve for until we have a date certain for evictions. And if we were able to transition Maryland to a world in which we have that date certain, a lot of what we do here would become unnecessary because it'd be clearer to both sides what the expectations are. So I just want to put that out there for future years.
Thank you so much. I just had a chance to read the Todman case. So here's, as quickly as I could. So it looks to me like this is very specifically a problem that existed in Baltimore City under their local abandonment ordinance. So what I'm a little confused about is, since the plaintiffs, the tenants won, they got $186,000 out of that case for the way that Baltimore City wrongfully dealt with their property. Now, bear in mind, Baltimore City has over 7,000 evictions a month or whatever. It's pretty extraordinary. So storing the properties, they have their own very unique challenges. So could somebody tell me if Baltimore City can fix this problem by altering their ordinance, why are we getting into a statewide bill? Was there evidence outside of this case that other jurisdictions needed this kind of help?
So, counsel, you can address it. I mean, look, the genesis of this, like as I said at the top of this debate, was a Baltimore City ruling, and the Todman family prevailed there because it was deemed that they had no due process because their property was deemed abandoned as soon as the eviction occurred.
Right.
And so they had no ability and no forum to say, hey, look, I need that reclamation period, I need that time. Baltimore City had I think a 7-day reclamation period on the books back in the day. Was it 4 days? And then the council got rid of that. And so when
that's right.
That's what triggered this kind of conflict, and that's what happened.
They got rid of it. Baltimore City.
Baltimore City.
Got rid of it.
Yeah. So that it was considered their property was abandoned the moment the eviction, the warrant of restitution was issued. So, look, we've got 24 jurisdictions in Maryland, and I don't know what the reclamation period is for all 24 jurisdictions, to be in all candor, unless you do, counsel. I don't have that information. Does anyone else have that for either side of the advocates?
Do you?
You're asking how many jurisdictions have eviction periods? There's zero. You're asking how many jurisdictions have abandonment statutes? I know specifically Prince George's County, Baltimore County, they have those abandonment provisions, which is I think 72% of the evictions in Maryland. So that's kind of how this came about. But that was kind of in regards to the reclamation period, which isn't a part of this part of the bill anymore.
I'm sorry. Okay, sorry. I'm sorry, sir, can you just come back for just a second? Thank you for being so helpful. Say that, give me your data again on this issue. You said what again, so I just.
Sure, so as you said, Baltimore City had an abandonment provision.
Right.
And that was deemed unconstitutional under the Todman decision by the Fourth Circuit. This was because of the lack of due process, as the chair spoke. The issue that this bill raised or was trying to initially try to solve was not only did Baltimore City have this abandonment provision, but also Prince George's County, Baltimore County, and some other smaller jurisdictions. But those three counties, which make up about 72% of all evictions, all had abandonment provisions.
Abandonment provisions, well, what's wrong with them though? I mean, you can have an abandonment provision, it's an ordinance, by the way.
Right.
But what's the, so there's they have local ordinances to determine when it's legally permissible to view the property as abandoned, and tenants do abandon their property in certain circumstances.
Right, so
you have to figure out, the law's trying to just give you some way to sort through that.
Right, so the Fourth Circuit found that for the purposes of abandonment of your personal property, there wasn't enough notice or due process.
In Baltimore City.
In Baltimore City, or a jurisdiction that has an abandonment provision, because there hasn't been enough guardrails or there wasn't enough due process to say, hey, you're coming to court, you're looking at an in-rim court process, which is the current way that we do things, which is just about the real property. And also you're at risk of you're losing your personal property. And that notice and that particular opportunity to be heard about your personal property wasn't baked into the in-rim process of how we do evictions here. And the problem arises because we have, or at least should say Baltimore City, instituted this abandonment provision, which meant that they were making this declaration that your property is immediately abandoned upon eviction, without this other opportunity to be heard notice provision. And that's where the Fourth Circuit landed on that.
Right, that's in Baltimore City. Do you know what goes on in Harford County?
There is no abandonment provision in Harford County, no.
But do you know how it's dealt with in Harford County, now the property's dealt
Oh,
with?
yeah, so in Harford County, my belief is that when the eviction occurs, the sheriff makes sure that the landlord has the required amount of workers that are out there to move out the property. They move the property out and they put that on the street. I believe that's the process in
All right, thank you.
Harford County.
All right.
Senator
Earlier, you had asked, you were looking for a sheriff, so I went out, because I saw Blindy from Baltimore City Sheriff's Department, so he's listening to the exchange, and he says, and I asked him whether or not I could share this, that he believes that the Baltimore City Sheriffs believes setting the minimum notice for a tenant holding over is important, and that they agree with the work group amendment, and he says that Senator West as well as Senator Henson were correct.
Thank you, Mr. Chair. So what I'm hearing you say is Todman decision, right, resulted out of the Fourth Circuit as a result of a local ordinance.
Yes.
Not anything wrong within the framework of the state law that's in place.
That is correct, yes.
Okay. So knowing that, you came up and you also gave this good sign of how many other jurisdictions of the 24, I believe, and I forget what the exact thing was, but no other jurisdictions for the additional days or whatever it was you were coming.
So no jurisdictions in the state of Maryland have a reclamation period.
Correct.
Reclamation period meaning that they provide the tenant the opportunity to come and get their property back.
Okay. But actually they do though, because they notify them they're getting evicted.
Well, no. So the reclamation period would be from the time of the eviction until whatever time. That's when they have that's what a reclamation period is.
So there's no other jurisdiction, none of the 24 jurisdictions of our state require a reclamation period?
No.
Okay. So why not just fix the ordinance of the 3 affected jurisdictions?
I mean, that's possible, but I mean, I think it is in the state's interest to make sure that the state
The state's law isn't the issue.
Well, can we frame this differently? Because you're right. So sometimes when, even though there are latencies or there are things that are not constitutional or violate due process in this instance, just because they haven't been identified or teased out doesn't mean they're not there. And sometimes a case like this in Baltimore City elucidates the problem that exists in other jurisdictions that is just identified by the court case. So the reason why these other jurisdictions are not quote unquote violating is because it just hasn't been challenged. It hasn't been brought to the court's attention yet. And so now that this case has been brought to the court's attention and it's been identified these other jurisdictions don't have those protections that the court in the Fourth Circuit has said you have to have, just because those other jurisdictions, do you know what I'm saying?
I understand exactly what you're saying, but I agree to disagree because this is about a local ordinance. This isn't anything to do with the state.
But the local ordinance identified a due process issue that existed throughout the entire state.
By the ordinance, not current state law.
No, so it existed throughout the entire state. It just hadn't been brought to the court's attention and identified or challenged yet. And so,
but that local ordinance doesn't, there isn't one across the entire state.
Trying to frame this properly and maybe help me out. So sometimes there are violations that exist in
I understand what you're trying to say, Mr. Chair.
And when they're, it's only when they're challenged through the court process that they're identified and dealt with, and then those things, it doesn't mean that they didn't exist in other jurisdictions. It just means that it hadn't been challenged yet.
But there's only 2 other jurisdictions that have this similar, or, I'm sorry? Prince George's and Baltimore County, you said, right? That have the
that they have abandonment provision.
The abandonment provision.
Yes.
So you had Baltimore City.
Yes.
Baltimore County.
Yeah. Well, there are more. I believe that there are other smaller counties, and I can provide you a list.
Yeah, but the three you've given, the 3 jurisdictions you've provided: Baltimore City, Baltimore County, Prince George.
Yes.
And
so that happens all the time in the law. So like, again, this due process violation has existed, but the court has now, because it's been challenged in one jurisdiction, the fact that those other 23 jurisdictions don't have a reclamation period under Todman, they've said, hey, look, you got to have something. It didn't say what it was, and I think they even under for the due process Matthews test, right? There's like a 3-part Matthews test. The court even in Matthews even said that they leave it. It's not their decision to decide what that looks like in terms of the time. It just says, there's got to be something, but it's an invitation for the legislature to fill that gap. And so this is what we're doing with this piece of legislation.
Thank you, Mr. Chair. So if the reclamation period, if those three, if those ordinances didn't exist for Baltimore City, Baltimore County, and Prince George's County, if they were not there, under current law, would this, in your opinion, and I'm asking you honestly, would this still have standing for the lawsuit?
If the abandonment provisions were removed in each county?
Correct. No.
Possibly, but here's the issue that we see is that when you're conducting an eviction, right, in most jurisdictions, you're taking a person's belongings out and you're putting it on the street, which means that anybody can just come and just start taking belongings, right? And so in practice, right, that kind of works as an abandonment type of way, right? So it's kind of quasi, even if the state doesn't say this is abandoned. In practice, it could be, but that's a whole different type of.
But you just said a minute ago that currently across the state, and there's nothing to the contrary aside from these 3 counties or jurisdictions with ordinances, that the sheriff contacts the landlord has employees that come and place the property on the curb.
I'm sorry, could you repeat that?
You said that the sheriff contacts the landlord and the tenant of the eviction, the time frame, and then the landlord hires or has employees that take the property and remove the property and place it to the curb, correct?
Correct.
And again, removing the ordinance part of this, with the notifications that were made up to the eviction time, what is the problem with the current law as it sits, other than what this law or what this bill is attempting to do is provide even more notifications and a longer period for the reclamation portion, right?
Right. So, I mean, I don't know if the amendment's been adopted, but the amendments would remove the reclamation period. So that wouldn't be something that you would discuss. And also, if I didn't misspeak, Washington County and Carroll County, they both have abandonment provisions as well. So we're actually at five counties.
Okay, thanks. Appreciate it.
Now, I want to go back to something one of my colleagues said here. We know the minimum is, but as you said, in some county councils, and I know a few, they can just go really wild with that. Is there any way of putting a maximum amount guardrails, and if so, what would we do to do?
So the only rationale for this number is because that's what the bill came in at. And so I would suggest,
So it's arbitrary.
To strike, well, I mean, we can give a policy rationale.
Well, Baltimore City has a 14-day notice provision.
Okay. Yeah. What I would suggest is that
maximum.
You do four minimum and not to be, or in a maximum of 14. Yeah. I mean.
Yeah.
If they don't have a local ordinance and we pass this, it'll be, the baseline will be 4, the floor will be 4. 4-day notice.
The county council can go up to
14.
14.
No, go ahead.
I think that's shocking to limit it as low as 4 days. So it would require the counties to take action if they wanted to do anything greater than 4 days. But I think if we're trying to really give a meaningful notice and opportunity to be heard, that I think the committee landed on a 7 days notice for a reason. But I hear the concern is that perhaps a county like our good senator from Western Maryland, if they're able to effect an eviction before that we want to give opportunities for that too. Is there a way to write the provision where perhaps those particular counties get the benefit of 4 day, but it doesn't put the pressure on the other county councils to rush in with an ordinance to be able to preserve the great work that brought us to 7? I mean.
No, I hear you. I hear you. One of the things that, I mean, I'm trying to like balance equities always. So for breach of lease, for failure to pay rent or tenant holding over, like there are different timelines for a minimum when, and even the advocates and proponents of the strongest version of this bill will admit that for failure to pay rent, the average is 60 days for an eviction. And so it's, and then there's a 10-day notice before, there's 10 day, the 60 days includes that 10-day, but the 10-day notice before you even file, then you've got 3 rights of redemption in every county except for 4. Baltimore City's 4 rights of redemption. You pay, you stay. So then, I want to make sure that we at least understand for people that are listening that it's not like, you get evicted and you're out. Like this process has been going on for 60 days. And so like, you are on notice that something is happening. And then to add on this 7 or 4, I think that is just on balance pretty, in my opinion, is reasonable. And then saying to the county councils, you can go up to 14 on top of the 60 that it's already taken to get to that 14 is, I think, reasonable.
Is the senator from Western Maryland going to support the bill if you drop it down to 4?
No, so look, I see things working. I'm not saying that, but look, there's nothing wrong with making a. There's nothing wrong. Look, people make. People make good bills better, and in his perception, bad bills more palatable. But
got it. Adopting a local ordinance is not as simple. I come from a county where it's a purple county, and we have a 4-3 on our county council. And so if we put something in place where the floor is so low, it's a very good likelihood that that's where it will remain for a county like Anne Arundel.
So I believe what she is suggesting is 7 unless a local government makes an affirmative action to lower it, which I think is fair.
So then you say it shall be 7, but you can deviate left or right.
7 days unless local government adopts something.
You can do that, and that way Allegheny County can go forward.
Yeah.
And then it puts it on Allegheny to say, I'm dropping down.
Right. Right.
Then you're not establishing. No, I'm saying, but then you lose the floor. I'm saying some jurisdictions will say, 24 hours, 4 hours.
We say to Senator Signor's point that the standard is 7 days unless a local ordinance is adopted that is not less than 4, not greater than 4.
Oh, so do the 4 that way. Okay, you could do that. Leave it to JPR to make this like hyper complicated. Senator West, go ahead.
Technical suggestion. So the notice currently under the committee modifications requires that the notice contain, quote, the scheduled date of the eviction. So my concern is there may be a reason why the eviction doesn't occur on the scheduled date, whether a lack of staffing in the sheriff's department that day, and it has to occur a day or 2 later. Because of the way the bill's written right now, there might be a legal argument that they'd have to start it all over again because this eviction did not occur on the scheduled date. So my suggestion is we change that language to read the scheduled date on or after which the eviction will occur. And that protects us in case you have to delay it a day or 2. Page 8. Page 8, line 13.
What page?
Page 8, line 13.
Thank you.
So for the law students here, I don't know if this process inspires or scares you all, but this is how the law is made.
So we changed the language to the scheduled date on or after which the eviction will occur.
Something like 7, not if you slide to the left, not to be less than a minimum of 4, and not to be anything more than a maximum of 14. Is that something that's palatable to both sides here? I'm not asking you guys to high five and run onto the sunset, but
just for clarity, so the bill would be 7 days, but then it will allow for localities to adopt.
To go as low as 4
To go as low as
and not
4.
more than 14. Go ahead.
I don't understand the issue there. We either have a floor, or you're gonna ask me to go to my local, to pass a local ordinance that's gonna go against what the recommended floor is for this. I mean, it's, then,
Most of the state can work with the 7 days. I think the unique part of Western Maryland is the uniquely short timeline that you all are able to affect an eviction in. So to hold the whole majority of the state for something that's unique to your area, I think the better approach is to give you the flexibility to do what works for your area, but not lower the standard for the rest of the state because of it.
Why not just take the rest of the state out of it? I mean, the rest of the state's not having this problem.
This county's not the only one.
And this is affecting every county. And to put in wording that says a specific, this is why by overcomplicating something that was seemingly 4 days is your base, is your floor, 14 days is your max. That window is very easily understandable to anybody that looks at it. When you start putting in a provision that says, well, we recommend 7 days, but you can go as low as 4 or as much as 14, now what you're doing is you're creating an opportunity for liability and conjecture by certain people in the legal community to say, oh, well, it says 7 days, but you guys went down here, so this is wrong. Just make it what it is, or remove the western part of the state out of it. There's not an issue with it.
Carver County.
I mean,
Thank you, Mr. Chair. Let me try it again. The Fourth Circuit, in the Todman decision, announced standards of what constitutes due process in this area. Even though it applied to a particular situation in a particular county, those standards are more universal than that. That under the Fourth Circuit's formulation, these are the minimum standards that must be adhered to in order to comply with due process. And so this bill is an attempt statewide to implement standards consistent with the Fourth Circuit's decision so that the process in any county in the state would comply with these standards and wouldn't run afoul of a future Fourth Circuit decision that you violated due process.
So that's absolutely correct. Where the tough part is that there was no specified, and that's the invitation for the legislature to act, is that there was no specified amount of time, which is what we're arguing over, so. No, it didn't. It said no. The 4 came from you, but it didn't specify. It could be, I mean, look, Prince George's County has what, hours, 4 hours? Okay, that technically could qualify, okay? We don't know. I mean, because the court didn't direct more specificity than some amount of time. So,
My county is 4 hours.
That's up. I won't interfere with Prince George, still have Prince George and Bill and Harvard.
all right, are you almost there? So the amendment right now has 7.
we had a amendment of 4.
We adopted the amendment at 7. Now we're still debating. Debating the 7, 4 floor, maximum 14. Let's go ahead, Senator West, let's adopt your other amendment. Can you read it? Council, can you read it real quick?
That would be Josh.
Oh, Josh, go ahead. I'm John. Senator West's amendment.
Can he say that one more time since, because we've, yes, can you say that again because there's been a lot of discussion?
Say my amendment on page 8, line 13. Will change the language to read, the scheduled date on or after which the eviction will occur.
Okay, so then it would say, the notice required under paragraph 1 of the subsection shall include the scheduled date on or after which an eviction will occur.
Thanks for joining us. Check out that Thurgood portrait. Good luck.
A little bit, only, so the intent of what you're saying, Senator West, we are on board with. The initial notice should be the only notice. I think with that language, it could open up the possibility the landlord give just the floor of the date of the eviction. So say your eviction is gonna happen on April 8th, and then they get an eviction on the 10th, right? And so the person, they're still kind of waiting or out in the atmosphere trying to figure out when their eviction date is. And so if there's like language that could just make sure that says this is the only notice of eviction the landlord needs to provide, I think we'd be okay with that. But if there's something along the lines of on or after, that might give a little issues for us, I think, just because I think under that language, a landlord could, theory, get an eviction, say you're going to be evicted from the 7th on, and then that person is still scrambling trying to figure out when that eviction date is coming. But I agree that we don't want the landlord to keep on coming back to give notice of eviction.
No, if there's snow and the landlord can't get in on the day of the noticed eviction, we don't want to have to start the process all over again.
Right.
To give a new date of an eviction, just because the landlord is going to have to get in 2 days later once the snow is removed.
Right. We agree with that. I mean, if there's some type of language just on the initial eviction date, they must give that notice, but anything after that, they don't need to.
Can you sit there and draft some language that you think is good? And
I'm just going on record to say we agree with the language, Senator West, that you proposed.
Thanks. Do you want to rough out some alternative language so I'm not flailing away here?
So I guess going back to what it was. Now, so instead of saying the scheduled date of eviction, we'd say the initial scheduled date of eviction. question just says the initial scheduled date of eviction.
Is everyone okay adopting the new language on page 8, line 13? All right, everyone's okay.
The days.
We're talking about 7. Is that what the House adopted then?
No, the House had a whole different bill.
So on this bill then, we've talked about 7 with the flexibility for locally to go to 4 to 14, which I don't know anywhere else in the law that something like that is crafted as far as like for this. I just think it creates a lot of issues for local So why wouldn't we just go, if you're going to leave that flexibility, just make it 1 to 14 days and leave it to the individual jurisdiction to.
If you read the opinion, starting at around page 21, and I don't take my word for it, just read it. It constantly talks about a brief period, a short period. It even references several hours, which I don't recommend myself, but my point is that they're saying for the due process and the notice that it does not have to be a long period. It has to be meaningful, but short and brief are replete in this opinion. And I don't think 7 days is reflective of that. And I will tell you in Hartford County, our practice would not need 7 days. So I think what the state is so good at, and usually that's the way the law works, is to set a minimum and allow the jurisdictions who have plenty of give and take and advocacy groups that can talk it through, give them a floor. And I don't know if you want to give them a ceiling, that's up to you all. And then let the jurisdictions, let's treat them like the grown-ups that they are, and let them sort out what works best in the balance of protecting tenants and protecting landlords and protecting the streets and not having clutter and abandoned property everywhere. That would be my suggestion. That seems to be what we do best and what we usually do.
I couldn't agree with you more, actually. And now that we've been talking around this, I know it's never everyone's gonna be happy, but I would suggest floor 4, maximum 14. I mean, what do you think? So a minimum of 4, but a maximum of 14. All right. Yeah.
Okay, so is this saying, instead of now where it says at least 7 days before the scheduled date, is it now just saying at least 4, but most 4, and we're getting rid of the local authorization part? Right, so we're just putting it into this one and getting, okay.
Floor is the floor, then why don't we trust them if they want to go beyond 14? I think if we want to set a floor, then and that's all we want to do, and we're trusting and deferring to our locals, I think that's a two-way street. I don't trust them to get their act together above 4. Okay. Yeah.
I hear what you're saying. I hear what you're saying.
Yeah.
So do we have? Yes.
Okay.
But we have it in theory, I guess?
Well, so have John read it out. Sorry, John, we're working your hard.
Language shall. At least 4 days before. At least. Okay. So now it should say, this is on page 7, starting in line 26. It should say, after court has issued a warrant of restitution, the landlord shall at least 4 days before, but not more than 14 days before the scheduled date of repossession as set by the sheriff, yada, yada, yada.
Sometimes it's called compromise.
Better let it go, because otherwise it's going to be 4 days.
We can be laboring longer. I'm sure we can make it better.
Tell us what you think.
See that language one more time? I think they're still working on it, but this is generally, so this would be starting here. So let's say at least 14 days before, but not more than, or at least 4 days before, not more than 14 days before.
And like for the warrant of restitution, so Shanika, let me ask you this. So the warrant of restitution is issued, okay, and that's after this whole thing. If you started with 7, so then the sheriff then sets a time to go execute that, okay? Senator McKay is saying that his sheriff, they will generally do something within 4 days. Baltimore, huh?
4 days after the 60, though.
Yeah. No, 100%, I agree, yeah. from the initial action, from like the notice of a filing of eviction all the way through. And it was the testimony, I mean, even,
You send them a 10-day notice. On the 14th, you file for summary ejectment. 4 days later, you're in court on the 18th for your hearing, and then you get your warrant of restitution after 4 more days have passed. That's not a 60-day process.
that's 20, what is that, 22 days? So that's the average, 22 days, but in Baltimore City, it's 2 months.
No, this is after you're late 1 day. So if my rent is due on the 1st and they don't pay it on the 1st, you can send them that 10-day notice on the 2nd. You just can't include the late fees on the 10 days notice because it's not technically late until the 5th, but you still send them the notice. It's not that they've been 30 days behind.
Well, I guess the difference is.
All right, for this notice piece, even the amendment we want to draft is going to be is a little bit more complicated and technical, so we're going to vote again tomorrow. I'm trying.
Okay.
I would like Senator West, Charles, and Henson to get together and hammer out this last bit with the language. And if you could come together with the advocates, just sit together, just this last point, hammer this through, and have something for our voting session tomorrow. Does that sound good with people?
Just don't have the,
Oh, Senator McKay, sorry, McKay, my fault, because you're in there as well. Participate. We're just not going to have another maybe moment, but Senator McKay, Charles, Henson, West. McKay, is that okay with you? All right. All right, we're going to hold on this bill then. We made some good progress.
I've got 2 amendments I did not add. We didn't vote on the 3rd because we don't.
Floor sessions tomorrow. Floor is at 10. Let's call it here right now, 6. All right.